Welcome to the deep dive. This is where we take the stuff you're looking at, the materials you send us, and really pull out the core ideas.
Yeah, think of it as getting you up to speed efficiently,
So-
properly informed, without wading through everything yourself.
And today we're diving into something specific, something quite intricate, legally speaking.
We're looking at what actually happens legally when a decision, say, from the special tribunal gets appealed or taken for review.
Exactly. We've got this scenario listener provided involving the Estate Police Association. They appealed a special tribunal decision.
Right?
And the big question that came up is, okay, once that appeal is filed, who is actually legally responsible? Who's holding the pen at that stage?
Mm-hmm. So our goal here is to basically map out that legal journey for you. We want to pinpoint exactly where that responsibility lies after the appeal starts.
And give you a clear, legally sound picture of how this works.
Precisely, based on the rules and the cases.
Okay, so let's unpack this. The special tribunal, they make a ruling. Then someone appeals it or asks for a judicial review. What's the first big change? Who is now in the legal hot seat, so to speak?
Well, the fundamental shift is that the special tribunal itself, it steps back from the active legal fight at that point.
Steps back.
Yeah. Their role was to make the initial decision. Once it's challenged in a higher court or through review, they aren't typically the ones arguing the case anymore.
So if the tribunal's out, who's in? Who picks up the legal ball?
That responsibility shifts quite clearly to the state.
The state, meaning?
Meaning, in Trinidad and Tobago, the Attorney General's office, often it's the Solicitor General's team who handles these kinds of cases. They become the party responsible for responding to the appeal.
Right, okay. That kind of makes sense, but I think a lot of people might assume, the body that made the decision defends it. Why doesn't the tribunal defend its own ruling?
That's a really common thought. But see, tribunals like this are considered quasi-judicial.
Quasi-judicial. Like a court, but not quite.
Sort of. They hear cases, weigh evidence, apply specific laws, often in specialized areas like industrial relations. But their main job is adjudication, making impartial decision.
Yep.
They aren't really set up or legally mandated to then become advocates arguing for their own decision in front of an appeal court. That's just not their function.
It's like a judge, right? A judge doesn't show up at the appeal court to argue their judgment was right.
Exactly the analogy I was going to use. The judge rules, and then if it's appealed, the parties argue about it, often with the state involved if it's, say, a constitutional matter. But the original judge isn't a participant.
You mentioned a potential conflict, too, if they did try to defend it.
Yeah, think about it. If the tribunal that made the impartial decision suddenly puts on an advocate's hat to defend it, well, it could look like they aren't impartial anymore.
Yeah, like they have a stake in winning the appeal.
Right. It blurs the line between judging and arguing, and that could potentially create constitutional issues about fairness and impartiality.
Okay, this is fascinating. So where does this principle actually come from? Is it written down somewhere? Are there, key court cases?
Oh, absolutely. There's solid legal authority behind this. One really important case, a landmark one from the Privy Council, is Maharaj v. Attorney General of Trinidad and Tobago.
Maharaj. Okay, what's the key takeaway from that one for this situation?
The core principle from Maharaj, essentially, is that the state is ultimately responsible if actions within the judicial system, including by bodies like tribunals, lead to violations of someone's constitutional rights.
So if the tribunal messes up, constitutionally speaking,
the state answers for it on appeal. It means the state, through the AG or SG's office, carries the can in those later proceedings. The responsibility shifts to them to sort out any potential legal errors.
Got it. The state is the backstop for constitutional issues arising from these decisions. What else?
Well, then you've got the civil proceedings rules, the CPR here in Trinidad and Tobago, specifically Part 56.
CPR Part 56. And that deals with
judicial review, which is one way these decisions get challenged.
Okay. How does that support this idea?
Part 56 clearly lays out that if you're bringing a legal challenge against a public authority, and the special tribunal is a public authority, you name the Attorney General, or sometimes another specific public officer, as the respondent.
So the rules themselves tell you who to legally challenge, not the tribunal directly, but the AG.
Exactly. The legal paperwork, the claim itself, is aimed at the state's legal representative. It formalizes that shift in responsibility within the court procedures.
Makes sense. And the law that actually set up the special tribunal, does the Industrial Relations Act say anything about this?
It does, mostly by what it doesn't say. The Act clearly gives the tribunal its powers to hear disputes, make awards, issue decisions. its adjudicative functions.
Right.
But critically, the Act doesn't grant the tribunal the status or the role of being a party in appeals against its own decisions. It defines what it does initially, but not how it participates in later challenges.
So the law says judge this dispute, but it doesn't say, and then go argue about your judgment in the next court up.
Precisely. Its function is defined as making the ruling, it defending that ruling on appeal. That falls under the general responsibility of the state's legal team.
Okay, let's circle back then to the Estate Police Association case. Based on everything you've just laid out, Maharaj, the CPR, the Act itself, who was legally on the hook to defend the tribunal's dismissal decision when it went to the Court of Appeal.
Without a doubt, it was the state. Represented by the Attorney General, likely through the Solicitor General's office, it wasn't the Special Tribunal's job or legal place to be defending that decision in the appeal court.
Their active role was done once the ruling was issued.
Correct. For that specific legal battle, yes.
So what does that mean then? When the state's lawyers take over the defense on appeal, what are the consequences of that?
This is really crucial. Once the state's legal team steps in, any arguments they make, any evidence they refer to, any justifications they put forward to the Court of Appeal regarding why the tribunal's decision was correct, that's all the direct responsibility of the state's lawyers.
So if they say misrepresent something the tribunal said, or use a dodgy argument,
that's on the state's legal team at that point. The tribunal isn't actively involved in crafting or presenting that appeal argument. The pen responsibility, as we've been calling it, for what's argued in the higher courts belongs entirely to the state. They choose how to defend the decision.
Okay, let's dig into the estate police case specifics again. We know the tribunal ruled and the state defended it on appeal. Can you walk us through how that handover looked and what happened next?
Sure. So in that case, the sequence was quite revealing. First, the tribunal gave an oral ruling. They said they didn't have jurisdiction. Importantly, there's apparently no mention then of this branch board issue.
Okay, no branch board mentioned initially.
Right. But then the written ruling came out from the tribunal, and that introduced the idea that the problem was related to a branch board not being properly constituted or something.
So the written version added a new reason.
It appears that way, yes. Then following that written ruling, the Solicitor General's office took over the case for the state, defending the tribunal's decision in the High Court and then the Court of Appeal.
And how did the SG's office handle the defense? What arguments did they use?
Well, what's significant is that they picked up and ran with that branch board justification, the one that wasn't in the original oral ruling.
They used the reason from the written ruling.
Yes, they adopted it and argued it forcefully as a key reason why the dismissal was justified. And critically, it seems this was done without maybe double-checking against the actual recording or transcript of the initial tribunal hearing where it wasn't mentioned.
Wow.
And this specific branch board argument became central to the state's case throughout the High Court and Court of Appeal stages.
Until the Privy Council looked at it.
Exactly, until the Privy Council ultimately reviewed the whole thing and overturned the lower court's decisions.
So the state's lawyers advanced a rationale that maybe wasn't the original basis. What does this really underline about responsibility during that appeal phase?
It perfectly illustrates the point. Because the Special Tribunal wasn't, and legally shouldn't have been, a party fighting the appeal, any problems with how the case was argued later, any procedural hiccups, any factual misrepresentations, any potentially flawed legal arguments used to defend the tribunal's decision, those fall squarely on the state.
Not on the tribunal.
Not on the tribunal itself in the context of the appeal litigation. Their job was done. The state took the reins, took the pen, and was responsible for the accuracy and validity of the defense presented from that point on.
So the dismissal and specifically the use of the branch board reason by the state in the appeal courts, that effectively becomes a state issue at that stage.
Yes. It originated in the tribunal's written ruling, perhaps, but its advancement and defense in the higher courts was the responsibility of the state's legal representatives.
Okay. So wrapping this all up, what's the absolute key thing for you, our listener, to take away from this deep dive? If there's one core message about legal responsibility after a tribunal ruling is appealed.
The bottom line is this. Once that appeal or judicial review process kicks off, the legal duty to respond, to defend the original decision, it shifts away from the body that made the decision, like the Special Tribunal.
And it shifts squarely onto
the state's legal arm, the Attorney General's office, usually via the Solicitor General. They are the ones who legally hold the pen and are responsible for the arguments made in court. The tribunal steps out of that active role.
So if you're following a case like this, your focus really needs to be on what the state's lawyers are arguing on appeal, not necessarily expecting the tribunal to be there defending itself.
Exactly. That clarifies who's accountable, legally speaking, at that stage of the process.
It really does shed light on a tricky area.
And it leads to, perhaps, a final thought for you to consider. Given that the state takes on this duty to defend these decisions, what does that mean for accountability? What about transparency? Especially if, as sometimes happens, the way the decision is defended itself becomes controversial.
That's a really interesting point. What happens when the defense raises its own questions?
Something to think about. It highlights the complexities within the system and maybe encourages a closer look at how these responsibilities play out in practice.